This is an interview of KrisAnne Hall. She's a radio talk show host. And my name is Boyce. I teach courses on the United States Constitution. And let's begin. We'll start because this is an interview about an Article 5 Constitutional Convention. We'll begin by reading what Article 5 actually says. Now, Article 5 says the Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution. And that's how the 27 amendments that we have, that's how we got them. But the other way, kind of Part B, is, or on the application of the legislatures of 2/3 of the several states, shall call a convention proposing amendments, plural, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by Congress. Now that has never been done in this Constitution. There's only been one constitutional convention, and that was in 1787 when the Articles of Confederation went into convention to be, quote, revised and amended, and the delegates took it upon themselves to scrap the Articles of Confederation, draft an entirely new document, our present Constitution, and even changed the rules for its ratification from unanimous to 3/4 of the states. I'd also like to preface the interview with a quotation by James Madison. Now, Mark Levin, who's one of the main people, also a radio talk show host, but on the other side of the fence on this, says, James Madison, father of the Constitution, strongly endorsed the use of Article 5 to call a convention, that would rein in a runaway government. But this is what James Madison actually said. He said, "You wish to know my sentiments on the project of another general convention. I shall give them to you with great frankness. If a general convention were to take place for the avowed and sole purpose of revising the Constitution, it would naturally consider itself as having a greater latitude than the Congress appointed to administer and support as well as to amend the system. It would consequently give greater agitation to the public mind. An election into it would be courted by the most violent partisans on both sides. It would probably consist of the most heterogeneous characters, would be the very focus of that flame which has already too much heated men of all parties, would no doubt contain individuals of insidious views who, under the mask of seeking alterations popular in some parts but inadmissible in other parts of the Union, might have a dangerous opportunity of sapping the very foundations of the fabric. Under all these circumstances, it seems scarcely to be presumable that the deliberations of the body could be conducted in harmony or terminate in the general good. Having witnessed the difficulties and dangers experienced in the first convention, which assembled under every propitious circumstance, I should tremble for the result of a second meeting in the present temper of America, and under all the disadvantages I mentioned." I don't know how he reads that as being a strong endorsement of a convention. So the question is, what's your take on it? Do you feel that the present temper in America is more or less conducive, more or less dangerous to have an Article 5 convention than it was back then?
Well, it's definitely more dangerous because we have very few people who understand constitutional principles, who understand how the Constitution is to be applied, and understand how we even got the Constitution to begin with. We have to teach people about the Constitution so that they'll have the background to know what an Article 5 convention should look like. For example, we have people who are endorsing Article 5 convention for the purpose of a balanced budget amendment. That's not the purpose for an Article 5 convention. That is cosmetic surgery. That's like doing open heart surgery on the Constitution because she needs a nose job. It's absolutely ridiculous. The Article 5 convention is a mechanism to offer up amendments to the Constitution where law does not apply.
There's a quotation that we're going to get to by James Madison saying that the purpose of the convention is to correct errors.
Right.
Never meant to rein in an abusive government.
So this is my perspective. If you want, I'm not opposed to Article 5 conventions. Our framers gave that. I believe, as Jefferson said, that at certain times with societal advancements and our becoming more knowledgeable and enlightened, there are certain things that we may need to tweak and fix. And that may be the case. But the problem is, we don't have the knowledge that it takes to do that. We have just enough knowledge to hurt ourselves.
Well, we've
And
been
if-
pretty dummied down.
Yeah, right. University of South Carolina just bucked at having to teach their students the Constitution. Their press corps said, the people in South Carolina, students in South Carolina start learning the Constitution since first grade. We don't need to teach it here. I mean, this is the kind of mentality that we have. If we are going to have an Article 5 convention as the correction of error, do you know why we should have Article 5? We should have Article 5 to return us back to the foundational understanding of the General Welfare Clause, to the foundational understanding of the Tax and Spending Clause, the foundational understanding of the Necessary and Proper Clause. These are things that we don't have to guess at. And as a matter of fact, just as an example for the General Welfare Clause, Madison gives one of the greatest illustrations and definitions of the General Welfare Clause that I've ever seen, as he's arguing in front of the legislators in 1792, opposing a cod fishery subsidy. And he's opposing this subsidy that's being proposed by Congress, subsidize the cod fishery industry, and he's saying, look, this is not what the General Welfare Clause means. If we were, and the whole purpose now of Article 5, the Article 5 movement, right, is to fix the out-of-control Congress.
That's the idea. Rein in
an unconstitutional federal government. How are we going to rein in an unconstitutional federal government with a balanced budget amendment? If we were to have an Article 5 convention with people who understood the convention, understood the Constitution, and we had a convention for the sole purpose, just supposing we could have for the sole purpose, of understanding the General Welfare Clause and applying it the way Madison explains it should be applied, we wouldn't need a balanced budget amendment. Because guess what?
The understanding
Right. If we applied the General Welfare Clause the way it's supposed to be applied, there'd be no EPA, there'd be no FDA, there'd be no FBI, there'd be no DHS, there'd be no Department of Interior, there'd be no IRS, there'd be no Federal Reserve. All of these things gone with one definition. We wouldn't need a balanced budget amendment because we would be operating at an unprecedented surplus with all these things gone.
So that being the case, let me play these next two video clips and see what your take is on what the real driving forces, what the agenda is behind the scenes is pushing this. Now this is one from the left and one from the right. Oh, missed it. Hold on, let me go back.
We are 5 days away from fundamentally transforming the United States of America.
Okay, and then the next one.
Because sometimes what you need is not a change of personnel, you need a change of structure.
So it would seem to me that in order to fundamentally transform America, it would take structural changes to the Constitution.
Well, obviously, I mean, and that's been the mode of operation of tyrants for a very long time. The history that I teach, we start off with William the Conqueror coming in eliminating common law in Great Britain. The limitation of the monarchy's power is in common law. William I eliminates common law, not by simply stepping up and saying, we'll have no more common law, but by replacing the judges in the court systems, by using those judges to bring foreign law into the kingdom, even when it's contrary to their common law, using the judicial system and the foreign law to drive landowners off of their land so that the king can take possession of their land and bring all his foreign friends over to occupy the land. Because if you want foreign law to rule, you've got to have the country occupied with people who like the foreign law better than the common law.
So we began to make those structural changes which enabled him to be able to make broader changes.
That's absolutely right. That's absolutely right. And so the one thing, the structural change that I see, the danger in this, is the very same thing that James Madison said in Federalist Papers 49 as being one of his greatest concerns with a future convention. And he explains in Federalist 45, look, the only reason this worked this time was because we came from a bloody revolution. A revolution that we saw such horror, such sacrifice, such waste of human life in the name of. He said it kept us all focused on liberty. He said a convention in the future without that motivation would simply become a political battle. A battle between parties, a battle between personalities. You would have people with their greed, their political avarice, their personal motivations, their little pet projects in control of a convention. He said, and ultimately what will happen is you will be asking the same people who created the problem to fix it.
That's right.
Because we will lack the problem.
Give them greater power in the name of fixing it.
Right. He basically told us it would become a Republican versus Democrat dog and pony show. I mean, they didn't have that then, but that's basically what he's telling us.
What do you think of this? This is Mark Levin.
As I said, when we have elections, we're not electing whether to comply with the Constitution or not. The Constitution isn't up for election. These individuals we elect have taken a solemn oath to uphold the Constitution, and they refuse. They will not do it.
This is their fundamental argument is that they're violating the Constitution, they won't obey the Constitution, they won't honor the Constitution, therefore we need to change the Constitution. And my thought is, why stop there? Right? We could solve all the problems of the world by just using that principle, by just amending the Ten Commandments. We amend the Ten Commandments, thieves would stop stealing, liars would stop lying, Bill Clinton would stop doing what he does. It would solve all the problems.
It is a fundamental lack of proper education, proper critical and logic thought. See, we have been raised in a society that thinks laws fix problems. That's how we have a whole entire regulatory system, right? Because laws don't work, we have to increase the power of the government through regulation. Laws don't work, so we'll make a regulation to make it better, right? And so what we have forgotten is laws don't stop crimes. The criminal justice system was not even designed to stop criminal activity. The criminal justice system was designed to identify criminal activity and set up a mechanism to punish criminals. Because laws don't stop crimes. There's only two things that will stop criminal activity: morality and force.
That's right. That's right. So as a nation, lose our morality, there's, how does the quote go? More need for masters. And that's from.
Yeah, I'm not sure, but it is absolutely the truth, because the more immoral, and it's just a human nature thing, this is proven throughout history, the more immoral a society becomes, the more they look to government to keep them safe. Safe from whom? Safe from themselves. And so the more you look to government to keep you safe from immoral behavior, because government cannot dictate morality. You cannot legislate morality, it doesn't work. Even if you try, it doesn't work. I mean, prohibition didn't work, the war on drugs is not working, and so legislating morality does not work. But what happens is, the government says, sure, we'll do this for you, of course we will, but you have to give us more power to apply the force necessary to keep you safe.
So the more immoral we become, the more enslaved we become.
The more powerful government becomes, and the more powerful government becomes, the less liberty the people have.
I pulled up this is a quote from James Madison, Federalist 43. He's always pointing and saying, oh, it's in the Federalist Papers, James Madison endorsed it. This is what he actually said. Moreover, talking about Article 5, but moreover equally enables the general and state governments to originate the amendment of errors as they be pointed out by experience on one side or the other. There's no quotation, I've yet to find any quotation that recommends, or the founders are recommending the use of Article 5 to rein in government that ignores the Constitution.
No, as a matter of fact, the quotes you will find are the responsibility of the people to get their public officials under control. Jefferson said that if once the people become inattentive to public affairs, you and I and governors and judges and legislators will all become wolves. He says it's the general nature of who we are in spite of specific circumstances. I find that very remarkable that Jefferson himself is saying, if you don't keep your finger on me, if you don't keep watching me all the time, he said, if just once you leave me alone, I'm going to become a wolf. We are a government instituted among men, deriving its just powers from the consent of the governed.
The buck stops with us.
Exactly. That's why we're a republic. We're a republic because we are supposed to be controlling our representatives. When we don't control our representatives, we're no longer a republic. We're a kingdom.
Now, his argument that they make is Mark Meckler and Mark Levin. I'll play Mark Levin first.
The Constitution's been rewritten and mangled and amended left and right by all three branches of the federal government.
Really? I mean, we only had 27 amendments. The first 10 of the Bill of Rights is 1791. So in over 200 years, there's only been 17 amendments, all of which were the result of Congress proposing amendments and being ratified by the states. So in the case of prohibition, repeal of prohibition by state ratifying convention. So that's just an outright lie that has been rewritten, mangled, and amended by all three branches of the federal government. No, it's only been through Congress.
Well, let me put it this way. I will agree with him on the sense that it's practically been doing that. Not technically, but practically it's happened that way. The president writing law, overturning law, setting aside law is a practical overriding of the Constitution. Congress ignoring the general welfare clause's limitations, the limitations on the powers of the Congress, and ignoring the power of the House through Article 1, Section 7, and Article 2, Section 4, and those types of things are a practical rewriting and a practical destruction of the Constitution. And the Supreme Court, of all people, I mean, they started going crazy in 1803 with Marbury versus Madison. But I think that argument actually works against their argument for the Article 5 Convention, because...
They're pointing to a practical application of violations of the
Right.
Constitution. But if I violate traffic laws, and I do it consistently, that doesn't change the traffic laws.
No,
Traffic laws
no,
are still in place. But they're using that as an argument as to why the Constitution needs to be fixed. Well, it's being violated and violated, therefore it needs to be fixed. Well,
No, but the problem
that's-
is not the
that's
Constitution.
changed. That's my point.
The Constitution is not broken.
That's my point.
But he is making your point. The Constitution is not what's broken. It is the government and its refusal to follow the Constitution that's broken. The men and women in government are broken. The political system is broken.
So-
And you're not going to fix that by amending the Constitution, because that takes an amending of this right here.
Again, but starts with
Yes,
with the people.
absolutely.
They've been twisting it and squishing it and turning it and tearing it and using it as a weapon against us for decades, right? For a very long time.
People will say, don't you support the Constitution? Why do you want to change it? I love the Constitution. I revere the Constitution. It's been changed. I call this a post-constitutional period. Quickly, an example, Obamacare, obvious. Congress passed a law it didn't even have the power to pass. The President of the United States signed a law he didn't have the power to sign. The Supreme Court upheld a law that is blatantly unconstitutional. They twisted the statute, changed the language of the statute, rewrote the statute, and this is going on all the time.
So he's using the argument that because they consistently violate the Constitution, that in some way has changed the Constitution.
Do you know what's interesting, though? There is a constitutional remedy to that problem. Article 1, Section 7. Article 1, Section 7, the power of the purse being vested in the House alone, fixes that problem. Congress has the tool, and we supposedly have a conservative Republican House who hates Obamacare, that it was shoved down their throats, right? If they hate it so much, they have the power under Article 1, Section 7 to defund it and get rid of it right now. Yesterday. They don't even have to wait. They could do it right now.
So they have the power, what they lack is the backbone, and the only way they can
Right.
develop the backbone is by we the people
That's right.
insisting they have
So
a backbone.
how is amending the Constitution going to enforce the power that they already have through the Constitution? And here's the question, though. How is the the balanced budget amendment going to stop this? Because that's all they want, is a balanced budget amendment. How is a balanced budget amendment going to stop Obamacare?
Sure, it's not. It's not.
It's
And-
not.
And virtually every balanced budget amendment that's been introduced, or been suggested, there's always an override provision. So they move any-
Well, you know what? I can balance any budget if you give me unlimited spending,
Sure.
right? If I can print money and collect debt unlimited, why do I need to, what's the difference? What's the point of having a balanced budget?
That's right, just tax more and print more.
Right, exactly. So the solution is not a balanced budget amendment. The solution is getting back to the intent of the General Welfare Clause and eliminating all of this unconstitutional spending.
And all the unconstitutional departments, if they're not spelled out
That's
in
right.
Section A, they shouldn't
Right.
be there, shouldn't exist.
Well, the understanding that the federal government's only purpose is foreign affairs. The only purpose of creating a central government was to be an ambassador on behalf of the states for foreign affairs. War, peace, negotiation, and foreign commerce, Madison called it. Everything else, internal within the states, is supposed to be left and remaining as a power of the states. The Commerce Clause was not supposed to allow the federal government to dictate policy to the states. It was an extension of the Congress of the federal government's power to create treaties with foreign governments. It was a way to say, hey, when we have treaties, those treaties are obviously going to involve all the states in the Union. So we have this Commerce Clause now so that the states will play nice with each other so that we can facilitate our foreign agreements.
It's never meant for the federal government to
No.
micromanage anything that has to do
Absolutely.
with...
The federal government
commerce.
has no business in state affairs, period.
Okay, now we come to another aspect. They always insist that, well, it can't be a runaway. It's impossible to be a runaway.
I was originally very skeptical of amending the Constitution by the state convention process. I, like many of you, was concerned it could turn into a runaway caucus. And as an ardent defender of the Constitution who reveres the brilliance of the framers, I assumed this would play disastrously into the hands of the statists. But today, I am a confident and enthusiastic advocate for the process. The text of Article 5 makes abundantly clear that there is a serious check in place. Whether the product of Congress or the state convention, a proposed amendment has no effect at all unless, quote, ratified by the legislatures of 3/4 of the several states or by the conventions of 3/4 thereof. This, ladies and gentlemen, should extinguish anxiety that the state convention process could hijack the Constitution. It is impossible.
Okay, that brings us now to here. They insist that it'll be the states that control the convention. The federal government will be out of the picture, it'll totally be the states. But here, Article 1, Section 8, the final paragraph, paragraph 22, this is the section that empowers Congress, various powers. The Congress is empowered to, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers, meaning calling the convention in Article 5, vested by this Constitution in the government of the United States or in any department or officer thereof. We were sure that Congress is going to focus in on that, and the Supreme Court's going to focus in on that, oh no, it's Congress who's going to set all the rules for the operation of the convention.
Well, we don't even have to look at that. Congress, the Congressional Research Service has published 2 papers now, one in 2012 and just in April of 2014, that lists out congressional power in a convention. And this is not the Congressional Research Service telling us congressional power. This is the Congressional Research Service reporting on what Congress has already identified as their role in an Article 5 through hearings. And I mean, this is not a new, Article 5 conventions are not a new issue. They have been debating this since the 1950s. They've already had Senate committee hearings, they've all had House hearings, they've all been advised on this. And the Congressional Research Service says unequivocally that Congress has given itself, believes it has great latitude in the power to call. See, Article 5 says that Congress shall call. And for the last 70 years, Congress has believed those words, the power to call, means that they have the power to determine whether a state's application is sufficient, whether the state's application is timely, meaning they have expiration dates. When we have enough applications that meet congressional standards, now Congress says, since they have the power to call, they will establish all the internal procedures within the convention. Not only that, they will also determine whether it will be a limited convention or not. Right, exactly. So here's my question. If it can't be a runaway convention, then how will it be limited? Who's going to limit it? Right? Because Congress believes if it's going to be a limited convention, they must have governing power over it to ensure that it's limited. They're going to be the police force to limit these conventions. Now let me ask you something. Our representatives, we would be sending our representatives, our delegates, to a convention to represent us, right? As the people from the states.
How those delegates are being selected.
Right, well, but I mean, all that aside, pretty perfect world,
Supposedly,
they represent us. How does a limited convention allow my representative to represent me? See, my state has to surrender its sovereignty and its full representation of its people to submit to the authority of a limited convention.
That's right. The delegates to a convention are vested with sovereignty.
Yes.
That's why the delegates to the convention of 1787 were able to take it upon themselves, even though they were sent there with the sole and express purpose of revising and amending the Articles of Confederation, to take it upon themselves to scrap the document, giving us an entirely new document, even changed the rules for its ratification.
Well, but they are vested with that kind of sovereignty because they are the representatives of the state. The state has sovereignty, and as representatives of that state, they carry that sovereignty with them. But they have to set that aside in order to have a limited convention. They have to say, no, I'm sorry, people of my state, I won't represent you properly. I know this is what you want, and this is what you want me to do, but I'm not going to do that.
Not going to happen.
But look at what who do they send to surrender their sovereignty to? Congress. They will have to surrender their sovereignty to Congress to maintain a limited convention, which means the federal government rules over the states again.
Right. So in order to limit the federal government, to boil it all down, in order to limit the federal government, they have to turn over their sovereignty to the federal government.
That's right.
Yeah,
That's right.
Good luck.
Now then they propose to you that we will control Congress. We'll control this convention. How is controlling Congress working out for us? I mean, isn't that the whole reason we're having a convention, because we can't control Congress, right? We have to have a convention because we can't control Congress. Well, their proposed idea, if Congress bucks them on their plan, on the whole purpose of having this convention and the states ruling over the convention, their proposed solution to a Congress trying to take over the convention, they'll sue Congress in federal court. The states will bring lawsuit against Congress in federal court. Okay, so federal courts are run by federal judges that are appointed by the federal government. What kind of a fair trial are our states going to get when the courts and the judges are run by the federal government that they're opposing?
That's a couple of slides we're going to get to.
Sweet.
This is Chief Justice Warren Burger of the Supreme Court was asked by Phyllis Schlafly of the possibility of there being a limited constitutional convention, or convention of the states, whatever you want to call it. If it's pursuant to Article 5, if it walks like a duck and it quacks like a duck, it's a duck. So a convention called, as per Article 5, is a constitutional convention by definition. Well, this is what Chief Justice Warren Burger had to say. He said, I have also repeatedly given my opinion that there is no effective way to limit or muzzle the actions of a constitutional convention. The convention could make its own rules and set its own agenda. Congress might try to limit the convention to one amendment or to one issue, but there is no way to assure that the convention will obey. After a convention is convened, it will be too late to stop the convention if we don't like its agenda. The meeting in 1787 ignored the limit placed by the Confederation Congress, quote, for the sole and express purpose, end quote. With George Washington as chairman, they were able to deliberate in total secrecy with no press coverage and no leaks. A constitutional convention today would be a free-for-all for special interest groups, television coverage, and press speculation. Our 1787 Constitution was referred to by several of its authors as a miracle. Whatever gain might be hoped for from a new constitutional convention could not be worth the risks involved. A new convention could plunge our nation into constitutional confusion and confrontation at every turn, with no assurance that focus would be on the subjects needing attention. I have discouraged the idea of a constitutional convention, and I am glad to see states rescinding their previous resolutions requesting a convention. In these bicentennial years, we should be celebrating its long life, not challenging its very existence. Whatever may need repair in our Constitution can be dealt with by specific amendments. Now here we have Michael Ferris has made this one here, the audio is a little low, so it might be hard to hear, but he's made the comment that anyone that says that the convention of 1787 exceeded their mandate, that those delegates exceeded their mandate, is an enemy of the Constitution. So here's...
Let me just start with a preface. Anybody that considers himself a friend of the Constitution of the United States, says that the Constitution was illegally adopted, has defamed the Constitution of the United States. And I don't know why in the world they consider themselves a friend of the Constitution. It is not true, and it is not loyal to the Constitution of the United States.
Okay.
Among the other domestic enemies of the Constitution are those who argue that it was illegal. To me, that's an enemy of the Constitution. So let me tell you the real history of the adoption of the Constitution. You've heard that the Constitution Convention was called for the limited purpose of the Articles of Confederation. Well, that's not true.
Now, Michael Farris is the founder of Patrick Henry College. Well, let's hear what Patrick Henry has to say about that. This Patrick Henry, 1787 Convention of the States, was a definite, okay. Patrick Henry says, quote, "I would make this inquiry about those worthy characters who composed a part of the late Federal Convention. I have the highest veneration for those gentlemen, but, sir, give me leave to demand what right had they to say we the people? Who authorized them to speak the language of we the people instead of we the states? The people gave them no power to use their name. That they exceeded their power is perfectly clear. The Federal Convention ought to have amended the old system. For this purpose, they were solely delegated. The object of their mission extended to no other considerations." So, Michael Farris, the founder of Patrick Henry College, just called Patrick Henry an enemy of the Constitution, just called Patrick Henry a traitor. Okay? Will the real traitor please stand up? I'm sorry to become so passionate about this. This is another one. I gotta laugh at this one. This is Mark Meckler, supposed...
Thank God in the last 2 weeks of that convention in 1787, that sweltering summer, that George Mason had the wisdom to stand and say something like this, probably a lot more eloquently than I. He said, "Are we so naive as to believe that a Congress and a government that has grown tyrannical will propose such amendments as would restrain its own tyranny?"
Something like this. Well, that's convenient. You could say anything. Here's what... Now, this is from James Madison's notes in the Federal Convention. This is what Mason actually said. Now, Madison is saying here, "Colonel Mason thought the plan of amending the Constitution exceptionable and dangerous, as the proposing of amendments in both the modes to depend in the first immediately and in the second ultimately on Congress. No amendments of the proper kind could ever be obtained by the people if the government should become oppressive, as he verily believed would be the case." This is the exact opposite of what Mark Meckler was just saying. So he points to the Federalist Papers, points to different founders, never accurately quote them, when in reality, when you look it up, they're saying the exact opposite.
You know, Mason was actually very vocal about his opposition to Article 5, and George Mason never said anything favorable to Article 5. There are quotations that you can find where framers supported Article 5. Why would they pull out people that never said anything favorable about Article 5 to actually use that to support themselves? I don't understand that. I mean, no serious revolutionary historian would ever assert that George Mason was in favor of an Article 5 convention.
Well, those that were in favor of having Article 5 in the Constitution certainly never intended it to be used
No,
to rein in those that ignore the Constitution.
no, but
Anymore
Madison,
than amending the Ten Commandments.
but what I'm saying here is Mason was never in favor of it for anyway. I mean, come on, pick and choose. If you're gonna cherry pick quotes, let's find one that works, okay?
That doesn't stop that. Well, he prefaced it by saying Mason may have said something like this.
I'm like, man, no.
Okay, here's
I'll
now.
disagree. Mason would have never said something like that.
This is Rob Nadelson now, and he's making the point that you made before. Now, he's one of them, but he's making your point about the federal courts here.
And if all of that wasn't enough, I would like to remind you that there are the possibilities of lawsuits all along the line. Anything that the convention does that is even arguably legal can and will be challenged in the courts. And contrary to what you may have heard, the courts have been willing to accept Article 5 disputes.
So he's saying, don't worry, it'll all be sorted out by the Supreme Court. They'll protect our rights.
But you know what? This is the amazing thing. And there are a handful of questions that I've proposed to Michael Ferris personally. There's a handful of questions that I've proposed to those people who've chosen to attack me based on my understanding of congressional opinion of Article 5 and my warnings about all these things. Because remember, I told you I'm not opposed to Article 5. I believe if I'm opposed to Article 5, that means I'm opposed to something that our framers gave us. I'm not opposed to that. I'm opposed to the way it's being applied and the ignorance and arrogance in which we are entering into this process. So I am trying to sort of vet out the solutions to these problems. And there's a handful of things that I've approached them with. And one thing that I asked Mr. Ferris was, okay, fine. How long is this going to take? How long before we see real solutions come from an Article 5 convention? And he said, well, and admitted that it would be a minimum of 5 years. A minimum of 5 years. I think we're looking more at 10 with all the lawsuits and all this stuff. But a minimum of 5 years. You tell me, the way this administration is moving like a freight train,
Chaos.
we don't have 5 years to fix this federal government.
This is also Rob Nadelson. I was saying,
Or liberal groups might very well sue and try to throw a monkey wrench into the convention with the same results.
there are hundreds and hundreds of liberal groups just waiting in the wings for the convention to be triggered that are on record as supporting an Article 5 convention. Now here's, so we're going to, ultimately it'll be entrusted, the point he's making is that ultimately it'll be entrusted to the Supreme Court, who we can count on to defend our rights.
Constitution in the United States or other countries as a model, or we come up with our own methods and our own draft.
You should certainly be aided by all the Constitution writing that has gone on since the end of World War II. I would not look to the U.S. Constitution if I were drafting a Constitution in the year 2012. I might look at the Constitution of South Africa.
I watched that happen. I watched it when it was broadcasted live. I transcribed it. It was so disturbing to my soul. I actually played it over and over again and transcribed it, and I wrote an article about it on my website. The woman is a liar. Okay, first off, she does what you said. She pulls quotes out about James Madison and John Adams and Abigail Adams and totally misquotes them and misapplies them and creates this situation where she's supporting this living, breathing document of our Constitution because, after all, we know the Constitution was written by a bunch of rich white guys who hated everybody but themselves and their money, who oppressed minorities, who oppressed women, and that's why we have to hate the Constitution. All of that flat out lie. All of it flat out lie. And so this is proof. Now, you know Justice Stevens has proposed an amendment for Article 5, don't you? He wants to amend the Second Amendment. He wants to amend the Second Amendment to read, he says, we'll solve all our problems by amending the Second Amendment to read, a well-regulated militia, being necessary for the security of the free state, the right of the people while in uniform to bear arms shall not be infringed.
So he's trying to codify the idea that the Second Amendment only applies
to the army.
to the army
a
and so on.
force called by Congress.
Well, I'd like to make the point, it says that the right of the people to keep and bear arms should not be infringed, and they try to say, well, it doesn't mean people as we know it, it means military and so on.
Right, exactly.
Then the question has to be asked, well, in the First Amendment, where Congress shall make the law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people to assemble and petition the government for redress of grievances. Did the word people all of a sudden change in definition from the First Amendment to the Second Amendment? Or does the word people in the First Amendment mean only the military has the right to assemble and petition government?
But this is our Supreme Court. Right? These are our Supreme Court justices who will ultimately decide these federal cases the states are going to take against the Congress.
Now, there is a solution.
Absolutely.
There is a solution.
There's a right now solution.
One of the main solutions, as I see it, is nullification, which is exercising the 10th Amendment. Of course, to do so, our state legislators have to develop the backbone to stand up to the federal government and interpose themselves between the federal government and the people that they supposedly represent. So this is Thomas Jefferson's statement as to how to deal with the abuses of power, which is what we have right now. It says, quote, in cases of an abuse of the delegated powers, the members of the general government being chosen by the people, but changed by the people would be the constitutional remedy. Right? Elect good people. But where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. And that the co-states recurring to their natural right, in cases not made federal, will concur in declaring these acts void and of no force, and will each take measures of its own for providing that neither these acts nor any others of the general government, not plainly and intentionally authorized by the Constitution, shall be exercised within their respective territories. And this works. This is how the Real ID Act was squashed and so on. This works. But they don't want to hear about nullification.
Well, it's a dirty secret that nullification is happening all over the place. States legalizing gay marriage are engaging in nullification of the Defense of Marriage Act. States that refuse to, that are legalizing marijuana are engaging in nullification of federal marijuana laws. See, everybody loves nullification when it's their thing, but they don't want to call it that because then that sheds light on the real solution to the problem, the sovereignty of the states. Now, the crazy thing is if the states are not sovereign, then there's no Constitution. Because the Constitution is a contract, and only sovereign entities can create a contractual relationship. And so the states created this Constitution, which created the central government. So if the states are not sovereign, then they can't have created the constitutional contract, which means the federal government does not legally exist. And if the federal government does not legally exist because the states are not sovereign, then we're not a republic, we're a kingdom. You know what else is ironic here? Is the Article 5 people hate nullification. I don't understand that. I don't get that.
That would solve the problem.
Well, not only that, they say it's unconstitutional, but nullification is based on sovereignty.
Based on the 10th Amendment.
It's based on sovereignty.
All powers not delegated to the federal.
So if you are in favor of Article 5, because the states will control the convention because they're sovereign, how can you be against nullification and deny the states their sovereignty?
So the states are standing up on their sovereignty and insisting on their 10th Amendment rights.
Right.
Yeah, they're hypocrites.
That's
the
right.
answer.
That's right.
They're hypocrites. These are some of the problems, main problems that people are concerned about, and what I see as the solutions. First one, the growing federal debt. Government needs to obey Article 1, Section 8, and that would reduce government costs by 80%, getting all these unconstitutional.
Article 1, Section 7 by defunding the stuff that already exists.
There you go. Okay, I'll have to add that. Illegal immigration. It's the duty of the federal government to protect the states against invasion. Article 4, Section 4, 20 to 30 million violators of our borders constitutes an invasion.
But when the federal government refuses to exercise the power that's been delegated to them, it is the responsibility of the states to secure their borders.
As Arizona tried to do. Okay. I'm going to teach a course. I'm going to do a little explanation about that and give an analogy as to what they're doing. Basically, the federal government, instead of protecting Arizona, instead teamed up with the countries of Central America against Arizona. Okay, oppressive environmental regulations. There's no constitutional authorization for the EPA to even exist. The states must stand up and interpose themselves between the people and these draconian regulations under the 10th Amendment. No-win wars. Constitution requires a declaration of war, not any UN resolution. We need to follow it. That would reduce costs tremendously if we weren't involved in wars all over the world. Abortion, Article 3, Section 2, empowers Congress to limit the Supreme Court and return the issue to the states, where pro-life groups could fight down on a level playing field. The only one in over 100 years, the only one to try to exercise this authority of Article 3, Section 2 to reign in the Supreme Court was Ron Paul in the Sanctity of Life Act. So all these so-called pro-life representatives that get elected and re-elected based on being pro-life, if they actually solved the problem, if they actually exercised the authority that they swear to and used it and solved the problem, they would lose their meal ticket to the next election. Therefore, it's not about to be resolved.
Well, but see, the whole key of all these things that we've listed here, the whole key is this. The key to independence is self-sufficiency. But in order to become self-sufficient in the states, you have to deny the federal funding. And we have been so addicted to the federal drug money that the states, it would be a matter of self-destruction for many of the states to operate without federal funding. But if they did this, and they said, okay, we're going to operate constitutionally now, you will not direct tax our people. You will, as our Constitution was established and our framers intended, you will collect taxes from the states based on the census and the population. We, the states, will collect the taxes from the people. We will pay our apportioned tax rate to the federal government, and we will only pay for the things that are constitutionally executed. Your states would have all the money that they need to fund whatever. If you want government subsidized health care, you could do it on a state level. And the states would have the money to do that, independent of the federal government, if they operated constitutionally.
If they operated constitutionally. That's right. All they have to do is obey the Constitution, not put it on the operating table. Money being devalued through inflation, the Constitution is real clear. It says Congress shall coin money, it says the value thereof. There's no constitutional authorization for the Congress to turn over its authority to coin money and set the value thereof to a group of private bankers, Federal Reserve. They need to get rid of that. Common Core, no constitutional authorization for government to be involved in dictating health care or education. And in the case of Common Core, interesting, it's my understanding that 45 of the 50 states had signed on to Common Core, sight unseen, to get the federal funding. And now they're stuck. Now what are they going to do? They can't afford to give the funding back, and they've signed on to something that
that's because the act that created the federal act that created the Department of Education explicitly states that the Department of Education shall not mandate curriculum or hiring practices or have any internal authority on procedures within the school districts. So Common Core cannot be mandated, not just simply because the federal government doesn't have the constitutional authority, because they don't, but federal law prohibits it. So they dangle the carrot and say, we will fund you. And actually made the states compete for the funding. They made it a competition. You compete for the funding, and we will give this funding to you, but guess what? You take this funding and you're going to have Common Core. It's a whole trick. It was a whole ruse. Let's take a break for a second. Was that my son trying to get in here? No. Okay. All right. Super. Because he knows where I am, and I just wanted to know. Okay.
Next one is our energy dependence. There's no constitutional authorization for the Department of Energy to exist.
No, that's a state issue. Absolutely a state issue.
Okay, that's it as far as the slides. go from this point and discuss what we've gone over. What other solutions do you see? I think we've pretty much established that an Article 5 convention is not the solution. That would be a disaster. What other solutions? We brought up
Well, nullification is the solution. Sovereignty is the solution. I mean, sovereignty in all cases is the solution. Sovereignty as the states, sovereignty as local governments, sovereignty as individuals. The solutions to our problem, and I wrote a book that's being published this week called Sovereign Duty that lays out all the solutions. You have your constitutional sheriff, you have nullification, you have the states taking back their power and the authority for them to do that. All of these things are our solutions. The people we're understanding that government derives its powers from the consent of the governed. And we've forgotten about that. We think that the government derives its powers from the Supreme Court opinions.
It would seem that the way to bring that about, though, is through education.
Absolutely.
The people have to be educated in the principles of Americanism.
That's why I do what I do.
Principles are founded on. Essentially, we need a revival in America.
No, we need a revolution of the mind.
Well, that's kind of what I'm saying.
Yeah.
It's a revival, not just of an understanding and appreciation of the Judeo-Christian principles that were founded on it. People's hearts are changed, but also an understanding of those principles that were founded on that keep us free. We can't preserve liberty, we can't defend liberty if we don't understand what it's based upon.
Well, I say if you cannot defend it if you cannot define it. If you cannot define liberty, you cannot defend it. Jefferson wrote in a letter, and I think it was to Hammond, he said, if a nation wishes to be ignorant and free, it wishes for what never was and never will be. And so what we need to understand is education. That's why I do what I do. That's why I travel around the country with no speaking fees, with no fees to the organizations whatsoever. And this is why I wrote that book, Sovereign Duty, to lay out the plan of the framers to control an out-of-control federal government. And we have to do this through education. Education is the only way because our ignorance is enslaving us.
So therein is the value of organizations like the John Birch Society, Eagle Forum, and so on, and some of the Tea Party groups. I can't say all the Tea Party groups. It's like Mark Meckler. He's billed as one of the co-founders of the Tea Party, but here if he gets his way, he'll destroy the Constitution and bring the country down with it. Some Tea Party groups are on the right track.
I think the Article 5 movement, because it will take so long, and they will be tied up in nothing but litigation after litigation after litigation, will be nothing but a colossal waste of time and taxpayer dollars.
While real problems aren't being addressed. That's kind of the point that Chief Justice Warren Burger was making. Someone looking for this quote. I have that quote on here. Jefferson.
Yeah.
I think I passed it. Yeah, I think I passed it.
You can insert it.
Cartoon, focusing on this cartoon I made. This is my creation here. This is Mark Levin saying it's totally safe to open the Con's gate. See, we have a leash on it.
Well, I want to suggest to anybody who is legitimately wanting to be educated on the process to pick up the Congressional Research Summaries report that was issued April 14th of 2014, I think. Mm-hmm. It's a 42-page document. And it is some of the greatest warnings. I mean, if we're going to do this, we need to be able to prepare to meet this hijacking. And I want to say, if you are an Article 5 proponent, you need to know what Congress thinks and you need to be prepared for it. And I did a week-long series on my radio show. They can catch the podcast on my website.
What's your website?
KrisAnneHall.com, KrisAnnehall.com. I have a mobile app. If they have an iPhone or an Android, they can download my mobile app for free and get all my podcasts for free. And there's a week-long series that I did on my radio show that I go walk through that document and show you exactly what Congress thinks its power is in a convention.
Okay. Do you think of anything that we may have missed? I think that pretty much wraps it up then. Thank you for the opportunity.
Oh, my pleasure.
Thank you, Chris.
Thank you.